Good morning to you, and also good morning to our listeners, and thank you very much for having me.
So I explain what the heart is of this is all about, is the fact that Zuma has accused Advocate Downer and journalist Karyn Maughan of leaking his medical information. But both Downer and Karyn Maughan want the summons against them set aside, saying it's abuse of the court processes. What are the strengths and merits of this case?
I would say they're quite slim. There is some points in which both the parties would need to answer to. Maybe let's look at where they would get that particular points or from the side of the former president. Now you have the National Prosecuting Authorities Act, which then tells you how a prosecutor is supposed to conduct him or herself. Then you have Section 41 of that particular act, which lists a list of offences and penalties. And then it says under that section, you are not allowed to disclose information that you have come across in the course and scope of your employment as a prosecutor or as a person who is employed by the NPA, unless you've been authorized by the head to disclose that particular information, or unless you're disclosing that information in the course and scope of your employment. Let's say you're in court, you submit some documents that will suffice as a valid defense. Now, what the former president is saying, Advocate Downer, in the way in which you conducted yourself by providing information or allegedly conducting or providing information to Ms. Karyn Maughan, you've breached the NPA Act because you've disclosed information that you ought not to have disclosed in the first place. By that, I find you guilty, or I want you to be found guilty in contravening the NPA Act. And in order to do that, I need to prosecute you because I've tried to lay a complaint against you. The NPA has come back and said that they don't find the case in this particular matter. And in using the Criminal Procedure Act, under Section 7 to Section 18, I then intend to go the way of private prosecution, which is why we had those proceedings that we had yesterday, in which the former president is then saying, because the NPA is not going to prosecute this matter, I so believe in it, in that I want to take it on myself and make sure that I'm able to prosecute and be able to prove beyond reasonable doubt that indeed these particular sections were broken by Advocate Downer. And one of the accomplices, or accused number 2 in this case, would be the journalist that received the information and published it, which is, in this case, Ms. Karyn Maughan.
Yeah. So, I mean, at the heart of it, as we know, is this medical document, and which were filed with the court papers. But Judge Pietermaritzburg, who is presiding over the corruption case in ruling on Zuma's failed plea challenging Downer's title to prosecute, found that the note didn't really contain anything that was significantly confidential. That's what he says. Does this make any difference, or is it the principle that's actually being challenged here?
It does not make any difference. Let's remember, or let's look at what the NPA Act says. It says that any information, it does not say any information relating to medical-related evidence or any medically related information. The medical information that could have been provided at a particular point in time, to me, adds to the essence to what was said to be protected at that particular point in time. What the former president is saying, I'm not against a journalist going in looking for information and publishing that information if it is in the public interest. But you can't have favors in which there are certain individuals which are going to be offered preference over others and be given information which is not yet out there in the public domain or cannot be used at any liberty before it is able to be accessible in that particular manner. There must have been a reason for the NPA Act being conducted or crafted in this particular manner, in terms of saying, we do not want to jeopardize information while it's still in the investigative stage. We want information to be obtained in an ordinary manner. So it's seeking a balance between freedom of speech, the obtaining of information so that it can be published for freedom of expression purposes. But that cannot mean that you need to flout the legal routes or the law in order to get the information in which you are regarding. So it does not matter whether it has medical information or not. What matters is, at the particular point in time in which the information was shared, was it information which was already in the public domain? If the answer is yes, then there's no case. But if the answer is no, you then look who was in custody of this particular information. Here was the legal duty to protect this information and make sure that it is not obtained by anyone. If that particular person is a prosecutor, then yes, because the NPA Act is clear as to how and when that particular information must be disclosed.
So when we look at now, obviously we know that this has been postponed. It's happening again next year, 2nd of February 2023. Explain some of the technicalities that need to be cleared for the court to actually proceed with this particular case.
We need to start with the matters which are going to come on the 8th and 9th of December. Let's call them the pre-litigation matters. The first one is the application by the Friends of the Coast, the amicus, who are going to say, Honorable Judge, you may not be well vested when it comes to matters of media freedom and the importance of the media being able to write whatever information that they need to write in the public interest. So we want to be Friends of the Court so they can be able to shed some light. I don't think that application will be opposed, and certainly is going to assist the court in coming to the correct decision. And then there's an urgent application in which Ms. Karyn Maughan is challenging the very existence of this particular action and saying, you don't have a certificate against me, you have a certificate against Advocate Downer. I don't know why I'm being brought to answer in this particular manner. Now, if you bring a matter on an urgent basis, there are then two legs in which you need to satisfy. Firstly, is the urgency, of which in this case, you then have to say, I have a legal interest that I seek to protect. There's no other alternative remedy other than going this urgent route. And the chances of success at a later stage, the balance of probabilities are in my favor. Now, I think that's where the application is going to fall short, because if you look at the NPA Act, Section 108 or 106, if I'm not sure, deals with the charge to prosecute. That would have been the opportune moment in time in which that particular defense or plea could have been raised, and not in a separate urgent application, which is going to take place outside the confines of the criminal proceedings which are already set in motion. Then from the side of Advocate Downer, one of the things in which he's raising is saying that the amount of security that you've got is not enough. You've deposited an amount of 90,000. My charges are going to be in excess of R1 million or approximately $1 million. Please bring it up before we even start, because I don't want to have a situation where if I win this particular case, you can't pay me at the end of the day. Now, the court will be given a discussion of deciding whether is R1 million a fair amount, can it be used or can it be reduced? So those are the type of arguments which are going to be discussed earlier. The impact of that is that if any of the parties win, meaning the applicants, in this case, Advocate Downer and Ms. Karyn Maughan win, then it basically makes moot the February applications or the set down dates that would be held in February, because they would have won their cases technically due to not being any stronger points in making sure that the dates which are going to follow in February are going to succeed. But if we move on to the February application, that's where we get into the crux of the matter. Technical points being, was the information in the hands of Advocate Downer? Was it information disclosed in a manner which is inappropriate? If the answer is yes, then it can be found guilty, either he pays a fine or is sent to prison. But most importantly, there's a criminal record that is going to be there. And I'm definitely sure that it will be raised at a later stage when the main application between the former president and Thales comes in, because the former president will then say, how can you have a person who has a criminal record prosecuting me? Can you please restart the discussion of the charge to prosecute in light of this new evidence?
So there's so much happening. There really is, because this is a sideshow to another sideshow, and there's the main act that is still going on, which we need to speak to, because as much as we've all now focused on what's happening with Karyn Maughan and Billy Downer, and we'll talk about what's happening with Billy Downer in a next question, but the reality is that we've still got to understand that this is now all part of the arms deal case, and we are sort of, our aim is being taken off the ball right now with everything that's happening on the sidelines. But let's talk to this. What are the implications of all of these delays and postponements? Can the arms deal case still carry on, or does it have to now stop so that we can deal with all the separate issues?
I think it's going to be further delayed. Let's remember where we are with all these, the cases which are taking place yesterday. We are still at the provincial division. So if there are any of the parties which are not going to be happy with the outcomes, they want to go to the SCA, they want to go to the court. Let's look at the amount of time that takes on its own before we even get to the main case, which hasn't been decided, by the way, even on the trial date basis. We don't even know when the trial date of the arms deal case is going to start. So it's going to add on to the further delays that have taken place in these particular matters. The worry on that when it comes to these particular delays is the quantity and the quality of evidence that has to be tested. In a criminal matter, the person has to be found guilty beyond reasonable doubt, meaning there must be no other explanation, other the explanation which has been brought by the state that would help to prove that the individual is guilty. Now, if you don't have the evidential material, either because it has been lost or it has been destroyed, or the human element, which are going to be individuals which are going to go into the witness box and be able to recall what exactly happened within 10, 15 years ago, then the quality and the existence or the strong ability of the case is going to dwindle. So, which is why it's important of why matters should be discussed and a trial should start and end within the shortest amount of time. With all these delays which are taking place, it is going to be detrimental to both parties because it would apply both ways. The state is going to lose vital evidence. Even the former president may lose vital evidence and witnesses that could have helped to exonerate him at the end of the day. Yeah. So delays, and more delays are going to come.
Yeah, and I mean, the way it's looking, this is years and years and years that we're still going to be sitting and watching and paying for this particular trial to see any justice, if anything, is going to be served here. But I mean, let's talk about that separate case now, because we also know that Zuma wants Advocate Downer, who's the lead prosecutor in Zuma's arm deal trial, to be recused from the case. What updates do we have on this separate issue now?
I think on that one, the spotlight should be on the justice system in terms of saying you have an application which has been sent to you when you're allocating the trial date in order to hear the arguments or the verbal arguments of both parties. Why aren't you settling this matter once and for all? I would have thought that maybe this would have been one of the questions would have been asked in the JSC interviews, for example, of saying what causes the delays in which applications would be made much earlier. But there's a lapse of time that takes place between that particular application being submitted and the hearing date and the delivery of the outcome. I don't even think that you are going to meet the November or December deadlines if the SCA or the Constitutional Court will be done at that particular point in time. So it's all these delays which are going to take place, in which the former president is still saying in those papers, Advocate Downer, you don't have charge to prosecute, not because you are not a prosecutor, but due to your conduct. You've conducted yourself in a manner which is unbecoming of a prosecutor. On that basis, I don't regard you having charged to prosecute, and I beg leave of the court to extend the definition of the charge to prosecute. The state, on the other hand, is saying, no, there is tried law. In fact, the SCA has decided on the matter and said that charging to prosecute is only limited to documentation. So if I'm employed by the NPA, have the very qualifications, I'm regarded as a fit and proper individual, and I'm a legal practitioner, I have full title to prosecute, I don't have to like you. Obviously, I'm going to be biased against you because I need to win. But at the end of the day, I'm ready to place in this particular court to make sure that I'm able to defend the interests of the state. So that's the work of which the court will still have to do at the end of the day. And it's a bit worrying that it's taking a bit of time before this matter is finalized. I would have thought that by this time, all those particular issues would have been done and dusted.
Yeah, I suppose we should learn by experience and what we've been seeing going on that nothing is going to go fast here. I just want to ask you something just pertaining to what we saw happening yesterday. And of course, this is a very emotive issue because the issue of freedom of media and the ability for the media to express themselves and to report on stories free and fairly is at the heart of a lot of people's arguments in all of this, and saying that an attack on Karyn is an attack on the freedom of media. I want to get the legal perspective, though, because I know there are a lot of emotions that are around this particular case, and rightly so. Rightly so. We need the law to take its course. But, you know, when it comes to the protection of the freedom of media, I think that's something that certainly I am, and I hope everybody is very passionate about. Is this right, though? Is this an attack on the freedom of media? The Zuma Foundation say it isn't. Jacob Zuma, former president, says it isn't. But how do you feel about this? I mean, in terms of the legal perspectives.
I would say it's not. Let's look at it in this particular sense. We all have to subscribe to a certain legal prescripts, whether we like it or not. In fact, the law is there to make sure that you all subscribe to it and you follow it to the T. Now, if there was a law that says that you can't report on matters or journalists can't report on matters which are in court, then I would worry and say, why not? The court must be a place which is open to every single individual. And if you want to report on any particular matter, then you can rightly do so. That even pertains to court matters which are there. You should have access to those documents if those documents are not classified as being private. However, where there's a problem in which I think this particular matter must sort of decide this particular issue and draw the line. It is in instances where the reporting or the information that ought to be reported is not ripe as yet to be reported on, due to the delicacy or the importance of the information which is supposed to be reported on, or due to the information being subject to an investigation. Now, the drafters or the legislatures of the National Prosecuting Act could not have inserted such an important clause if they didn't see the need of that clause being inserted. So it simply says, in instances where we are still investigating, you will get your opportunity to report on the matter on the later stage. However, while the matter is still sensitive, while the matter is still on the side of the prosecuting authority, while it's still been decided on, and while it hasn't been submitted to court as yet, don't publish that information because you are not allowed to have that information. But secondly, there are proper channels in which you have, if you want to inquire whether certain matters are going to court or not and what is going to be used, which is why you would have the spokesperson of the NPA or the media liaison officer to deal with as members of the media. Strictly speaking, prosecutors should not be communicating with any media personalities or any journalist, because the proper channels in which you're supposed to follow that, you would go to the NPA communications offices, and that's where you're going to get the information that you require. However, if you feel that that particular liaison office is not doing any justice, then you go to court and say, I want to have access to this particular case or court file so that I can be able to deal with the information then. In this case, I do not think it's a fight against media freedom. However, it's a fight of saying, make sure that you subscribe to the law and you obey the law regardless of who you are, regardless how emotive or important your intention of disclosing the information is. The law is the law, and it should be followed regardless of what happened. I would have had a problem if they would have said they don't want anything to be disclosed at all. Then I would have said, yes, that's an attack on media freedom. But as it is simply saying, follow the law to the T, make sure that you're able to follow it at all times, and report on matters when they arrive to be reported on. And in instances where you feel that you have been hard done, there are avenues that are there to make sure that you get free.
All right, we leave it there. Thank you. Thanks so much for talking to us.